Namaskaram, this is Seshadri. Today we are going to see the labor codes which are proposed and passed by the central government. Now we are waiting for the state specific rules on these codes. So unless this state specific rules comes, we will not be having much larger clarity on that codes. Still, we should know what are all the changes are happening. So in this today we have taken contract labor management. So let us see how the contract labor management is going to change its position. So proposed act is contract labor management is comes under the code of the Occupational Safety, Health and Working Conditions Code 2020. So in this code, what are all the things going to happen or changes going to happen to us? So in the present contract labor management system consists of Contract Labor Regulation and Abolition Act 1970, usually called as CLRA Act, and applicable provisions of the other acts like PFI, ESI Act, and Payment of Wages Act, those things, and case laws as well as judgment. So put together only contract labor management system is working in the present scenario. The proposed scenario also going to be like that. Only one thing is the Occupational Safety, Health and Working Conditions Code is going to play the primary role, and applicable provisions of other codes, Social Security codes like that, and case laws will continue as part of contract labor management system. So what is the applicability? Chapter 1, Section 1(4) clearly defines, as of now under CLRA Act, 20 or more workmen if the establishment employs or contractor is having, then the act is applicable. The proposed act, Section 45(1) under Chapter 11 clearly says it is going to be 20 is going to be changed as a 50. So 50 are workmen if any establishment wants to employ under contract or any contractor is having 50 or more, then this act will become applicable. Already, this is not a new. Already, Maharashtra, Andhra Pradesh, Uttar Pradesh, Union Territory of Ladakh, they have already increased the criteria of 20 to 50. So it is not a new for some states, and some states, yes, it is new. Then definition. So under CLRA Act, who is the contract labor? Contract labor in or in connection with the work of an establishment is a contract labor. In the proposed act, it is saying also same. Only one thing is it is included the interstate migrant worker under the contract labor definition. So that also it is going to applicable. As well as in employer, the principal employer is the only employer under contract labor abolition act. But in the proposed act, contractor also elevated or equated like a principal employer is also called one of the employer. And licensing. Chapter 4, Section 12 and 13 talks about licensing under CLRA Act. Both in the present system, both the employer as well as the contractor, both are equally responsible and both have to get the license. As you know, as a principal employer, we should get license under that is called as registration certificate. And contractors, they have when the principal employer issues Form 5, contractor has to obtain the license. These licenses are valid for a specific period, that is 1 year usually. And in the proposed act, for section 47, it is clearly saying the major change is principal employer not required to take any license. Only contractor has to obtain the license. Unless contractor is having the license, he cannot get any contract work under this act. So before getting the contract work order, employer, that contractor should have the license. Then that license also, there are two types of license. So central government is going to specify criteria as well as qualification to get like contract labor license. If the person is meeting, contractor is meeting those criteria as well as qualification, he will be given the license for 5 years. So it is a spot specific period. And who are all not meeting the qualification or criteria, then they will be given as a work specific license. So there are two types of license. One is a specific who are meeting the criteria and who are not meeting the criteria. And you can see section 3 in 47 subsection 3a, it is clearly saying when we are getting the license, some things are clearly specified like working hours, fixation of wage, and essential amenities in respect of contract labor is specified in the license. As well as there are two issuing authorities. This license authorities are two. One is state government, another one is central government. When state government, if your contractor is doing the contract manpower only in the specific state, then state specific license will be issued. In case the contractor is having the business more than one state, or he wants to do pan India, then it is issuing authority shifted to central government. So central government will issue the license and not a state government. So initially he has to appraise the specific state and then it is shifted to some state central government. There is a electronic application. It is not a physical application. Earlier it was a, we have to get the RC under specific copy in physical form, but in the proposed act it is everything in electronic application. There will be a common license also possible between the contractor, factories, industrial premises. There is a common license also possible, as well as separately also we can get as a part of license. But under section 51, contractor has to intimate the authority once he gets the work order from the establishment. That also specifically it is referred under section 119. So next we come to payment of wages. As on the present CLRA Act clearly says, contractor is the responsible for payment of wages to the contract workman. Principal employer has to nominate one person for disbursement. As well as in case contractor fails, principal employer is liable. In the proposed act also, it is almost same. Only one thing is changed. Payment shall be made through bank transfer and inform the principal employer. Instead of nominating the representative, contractor can pay through bank transfer and give the information to the principal employer. And next come to welfare and health under CLRA Act under chapter 5 section 16 to 19 it talks contractor is responsible for canteen, restroom, drinking water, latrines, urinals, first aid, everything, all the welfare and health facilities liability it's on contractor. But in the proposed act section 53 clearly defines principal employer is responsible for health, safety, working condition which are specified in the section 23 of chapter 5, as well as welfare provisions which are specified in section 24 in under chapter 6. So principal employer is the response. This is a major change from that is a liable responsibility is shifted from contractor to principal employer. And prohibition, as everybody knows under CLRA Act we cannot engage for perennial nature of work. Contract we cannot engage contract labor, but there is a exemption also is there. Government is desires that activity can be outsourced. Yes, they can issue the license, as well as the perennial nature also in case of incidental or necessary for the industry. They that is government is the final authority. That is an exemption given under CLRA Act section 10. And the proposed act clears section 57 very much clearly says where we cannot engage contract labor. That is called core activities. What is core activities? May engage core activities defined in the section 2p. So before that, we can see there is an exemption also given under section 57. In case normally done through contractor, do not require any full-time worker or sudden increase of volume. Suddenly volume increase, then core activity also we can engage contract manpower. Under section 2p defines what is core activity, which core activity is any activity for which the establishment is set up and includes any activity which is essential or necessary to such activity, that is called core activity. So what is the purpose for the establishment is set up, that is core activity, which government who is appointing the authority, they can decide whether that is a core activity or not. And the following are considered as an allied activity. It is not a core activity if that establishment is not particularly for that purpose. What are all those things? Sanitation works. These are all allied work activity. This is specified under section 2p of the Act. That is definition. Sanitation work, including sweeping, cleaning, dust, as well as security services, canteen and catering services, loading and unloading, and running of hospitals, training center, institution, clubs, those things in and courier services, civil and other constructional works, including maintenance. That is building maintenance, not a machine maintenance. Then gardening and maintenance of lawns, housekeeping, laundry services, and transport services, and the intermittent nature of work. Those things are it is specified. Those are all can be treated as a non-core activity, and we can engage in these activities, contract labor. So these are all the things which is specified in the proposed act. Once there is a small changes are going to happen. Only thing we will be clearly knowing once the state specific rules are coming, that time we will be knowing the proper things. But still there is some clarification also required, because these are all the things which are not specified clearly. Who is the responsible for bonus, earn leave, maternity benefits, and gratuity of the contract workman? Either it is a principal employer or contractor. It is not specifically explained. As well as if the contract employees are less than 50, how they will be protected. So this is also a very good question arise in front of us. So if you are having any answers to this clarification to these questions, please reply in this YouTube channel comment box, as well as please subscribe and please give your views also. Your views are very, very essential for us. It is very important. Please subscribe, like, and share this video. We are the people who is HR professionals. We provide all support services to you. We are ready to serve you. Any queries, anything required, please call us. Please write us. We provide recruitment, training, compliance, payroll outsourcing, ERP development, website development, everything we do. We will be coming back with another video on labor codes, particular topics shortly. Please subscribe and wait for us. We will learn more things through this channel. Thank you for watching. Thank you.